Right, I will start Stride again. Stride is a case that I don't think necessarily told us a huge amount of new material, but I think where Stride was particularly helpful, excuse me if I move the phone so I'm not, that's better. Don't think gave us a huge amount of new material, but I think it's very a useful case in the sense that it emphasised a point that's worth being aware of if you're giving advice on decision making, and it concerned a decision by the council about master planning. A lot of development and quite a lot of the land was owned by the council, and the claimant's challenge, the principal ground of challenge, was that the public were unlawfully excluded from part of the meeting which the decision to begin master planning and commence negotiations with other landowners were made. The point that the council relied upon was, as colleagues will be more than aware, is section 101A of the 72 Act, which is meetings open to public unless disclosure of exempt information. And the exempt information in this particular case, it related to the financial or business affairs of any particular person, including the authority holding that information. In planning terms, obviously, information is not exempt information if it relates to proposed development for which the local planning authority may grant itself planning permission or permission. And also, the authority was quite entitled to grant itself planning permission under the general regulations of 1992. So the local authority which owned the land they proposed development, which is also a planning authority, was obliged to determine the planning application and was empowered to do so. But obviously there was the balance between the 72 Act and Schedule 12A in terms of public access or not public access. And what the court said was that there were two competing readings of the relevant legislation. The paragraph 9 exclusion applies only where the planning authority is considering a planning application, and as the council were considering how to proceed as landowner in negotiations with other landowners and working master planning ideas, the council maintained it was entitled to exclude the public when discussing commercially sensitive matters. The claimant contended a more broader meaning, namely that there was no distinction in the regulations between the authority's hat wearing, namely as local authority landowner or local authority planning authority. So all meetings at which the proposed development should have been open, and the judge rejected both interpretations offered by the parties, very bold, saying that there must be some connection between information relating to the development and the grant of permission for that development. It doesn't suggest that as soon as an authority as landowner proposes development, then information relating to it cannot be exempt, however far in the future and however unlikely the grant of planning permission may be. But on the other hand, the legislative framework shouldn't be construed so narrowly as to require the disclosure of other exempt information only when the authority is determining a planning application as an LPA. If an application has been made and the authority meets to consider how to progress it, then there's no reason to exclude the public. The judge said that there's a balance in the statutory scheme between the promotion of public access and safeguarding of financial and business interests, including that of the authority. But in this particular scenario, once the authority have applied for planning permission, the safeguard should no longer apply. So on the facts of the case, as the proposals were at an early stage, the claim was dismissed. The council's position was upheld because the prejudice that disclosure could cause in negotiations with other landowners was a legitimate concern. So it's a useful one in terms of openness and accessibility, and obviously the interplay between planning and that is particularly relevant, and the interplay between the local authority as a landowner and local planning authority. But I think it also emphasises the discretion that needs to be exercised is not if you like, a linear area. There's always going to be a grey area. What's important is being able, I think, to justify it on robust and reasonable grounds. A case that I mentioned previously, but I'm going to mention again because it just keeps on popping up, or the issue keeps on popping up, is Williams. I'll be brief on this, but the reason I mention it is because we still continue to get instructed to provide advice, usually in something resembling the following terms. The lawyer concerned from the local authority approaches us and says that they've provided advice to the senior management team, leading members, to late as applicable, or both, and they've gone, surely not, and we're asked to confirm basically what they've quite rightly advised. The issue that keeps on popping up is the very simple one, which is this is such a significant matter, it can't be dealt with by the executive, it must be dealt with by full council. What Williams, and it's a Court of Appeal judgment, made very, very clear, and it's just worthwhile having this very firmly in your back pocket and waving it around because it does seem to come up far too often, is that the legislation is very, very clear in terms of it's a legislative decision, not it's a very significant or very politically contentious decision, therefore it must be referred to full council. There are ways in which you can get a view from full council, sometimes on an executive decision before the executive make it, or dare I say it, scrutiny to give backbenchers an opportunity. But it's not a political decision as to where decisions are made. It's a legal decision and it follows the law. And the issue particularly that came up in this particular case involving Caerphilly County Borough Council related to the interplay between the decision and the budget. And again, if you ever get a situation where the argument is that because of the interplay between the decision and the budget, the matter should go to full council because of the budget and policy framework exemption from executive decision making, do bear in mind that that is given a very narrow meaning. Otherwise, any strategy is likely to have some financial implications. And just because it is a strategy that might have financial implications doesn't mean to say that it bounces into full council. You're actually going to need to have some very specific financial commitment in the strategy. And if it's just a case of by approving the strategy at some point in the future, there will need to be further decisions in relation to budget. Well, those decisions will need to be made, but that doesn't make it a full council decision. So keep Williams in mind. It seems to come up too often, I'm afraid, and occupy too much of people's time. But there we go. PIFs, which is a fantastic name for a case, is all about local government ombudsman rather than councils, but occasionally you get arguments about what's called functus officio, which is a fantastic Latin phrase, and if in doubt, throw a bit of Latin around. It just helps people put a smile on their face for the day. But it means that once a decision has been made, it's outside the decision maker's powers to alter it, change it, vary it, or do it again. Not something that generally bothers local government, but it can sometimes be raised and argued. PIFs was all about the local government ombudsman and about their powers. It is going on appeal, so it's worthwhile just keeping a very small eye on it, simply because at the moment, the decision that we had cited here in 2022 was a High Court decision, and it really basically reiterated the principles that we had before. And in this particular case, the particular facts and the circumstances applicable to the local government ombudsman, looking at the legislation, the court held that it was within the power of the ombudsman to issue a revised and in fact changed report as to their findings on a particular matter because they were made aware of certain changed circumstances or their understanding changed. The argument being that in fact they didn't have the power to do it, and that's what will be taken up on appeal. It's unlikely to have significant impact on councils, but there is sometimes an argument about the ability to go back and make a decision again, particularly as that's sometimes an attractive way of dealing with a pre-action protocol letter under JR. There's no suggestion that the same principles will be applied to local government, but it's just one to keep an eye on. And if anybody raises this issue, it's a very good starting point to understand what the hell functus officio actually is. Of more direct interest is the CPRE case, because as everybody will understand, it's common knowledge that when it comes to administrative decision-making, justice not only needs to be done, but needs to be seen to be done. And in other words, the mere appearance of bias is sufficient to render unlawful decisions made by public bodies. You can go back to the previous slide, actually, please. I haven't quite got to the turnover yet. Brilliant, thank you. Is the case at the bottom. So any would-be claimant doesn't need to demonstrate the decision was affected by actual bias on the part of the decision maker. Appearance of bias is sufficient to render the issue a problem. And treading the line between politicians and administrative decision-making isn't an easy task. And you will also be aware that because of code of conduct issues, councillors are precluded from sitting on planning committees to determine a planning application where they have a particular type of interest. And what the High Court did on the 8th of November was consider the interplay between what I would describe as the code of conduct / bias regime and the legality of decision making, because sometimes you can have members who argue that the code of conduct is their responsibility and their responsibility only. And how dare you, the corporate lawyer, the lawyer advising a committee, the monitoring officer, tell them what they can or cannot do, or advise them that they should withdraw or whatever, or declare an interest and not participate, because it's nothing to do with you. And you try to explain to them that it might actually prejudice the decision. And they say, well, actually, this is all about the code of conduct. And ultimately, it's my decision and I'll take advice when I want it. And I didn't ask for it. And that's kind of what came out of this. And what the court held was that a breach of the code in the would not in the circumstances have provided a single freestanding ground for challenging the result of the decision, because the Localism Act says, Section 288(4), a failure to comply with the code is not to be dealt with otherwise than in accordance with the arrangements made under subsection 6. And in particular, a decision isn't invalidated because something that occurred in the process of making the decision involved a failure to comply. So any breach of the code of conduct doesn't automatically render a resulting decision unlawful, but the court said that this did not mean that a breach of the code was irrelevant to the validity of the decision. Nice head of a pin U-turn there. Is a factor that a fair-minded and informed observer will take into account when deciding whether there was a real possibility of bias. The fair-minded observer would consider that a member who had no prejudicial interest was less likely to be biased, and that, other things being equal, a member who had a prejudicial interest was more likely. The judge expressed the view that this was, however, to be caveated on the basis that the definition of prejudicial interest within the code was a reasonable one. So I'll just pause there briefly and say that one of the things that I'm sure some people will be doing who have been alerted to this case is considering how they have defined a prejudicial interest within their code. Many people I know are moving towards or have adopted the LGA code, which I think contains a very clear and unequivocal definition. But nevertheless, the judge made the point that this assumption is based on how that is defined. The court went on to say that there was a real possibility of bias in this case and quashed the decision. The judge noted that whilst there is authority supporting the view that where bias or predetermination on the part of one member is found, the whole decision shouldn't be quashed, but the vote was 6-5 in favour, and given the councillor's positions as chair and vice chair, he decided that the permission should be quashed. So I think that's a very interesting case and one that's worth bearing in mind. I'm not suggesting you should all rush away and consider your codes of conduct and your definition of prejudicial interests, although you might want to do so, but it's more the case of it's a useful decision to be able to wave at members who tell you that it's not your business to tell them what they can and can't do, because it absolutely is if you're the monitoring officer. Next page, please. Now, Robinson is a case that's been around for a while, but I do think it's so significant it's worth a mention. I don't think it again necessarily tells us anything new in terms of how code of conduct complaints are dealt with. But where I think Robinson is very helpful is if you are involved in the business of investigating a complaint locally and you're dealing with any Article 10 issue, it gives you a very clear, I think, steer as to the approach that you need to take. It's not the only thing that's useful in Robinson, because Robinson also goes, I think, some way to trying to give the investigator, often the MO or the DMMO, some clear guidance about tying up evidential points, particularly in relation, in this case, in terms of making a judgment call in the absence of any evidence about what was or was not said and who said it and so on and so forth. So there's some good steers in here about that, but it is particularly Article 10 and the judge really underscored, I think, what we already knew, but made it very, very clear that councillors get enhanced protection in pretty generous circumstances because the interference, if it doesn't fulfil a pressing social need and isn't proportionate to protect the reputation of other councillors, shouldn't be allowed. And if interference isn't allowed, councillors carry on speaking without worrying about breach of the code, getting enhanced protection afforded to expression of political opinions on matters of public interest and freedom of expression, even if the criticism or the words used by the councillor is misrepresentation, untruthful, and indeed offensive. And it's just a really, I think, good summary and capture of the key points, but stresses the fact that, and this is always difficult to explain, that a councillor who says, and sometimes does, but certainly says things that people think shouldn't be allowed, is allowed because Article 10 gives a substantial degree of freedom to councillors, because that's what the public interest demands. But often expectations are different. And sometimes it's difficult to explain these things to people. And so Robinson can be useful as a ruler, where you can share the case with, for example, senior officers who don't understand why what Councillor X just did isn't wrong. The planning case, it's a pretty narrow point. It's only recently come up, and it relates to delegation, in this case, between the planning inspector and a planning officer working in the planning inspectorate, PINS. There's no suggestion that it applies to local authorities in terms of the law relating to delegation. Indeed, this is an express point in the judgment which says this won't apply because the legislative regime for local authorities is different. But the essence of the decision was that the planning officer, rather than the planning inspector, carried out the site visit and exercised judgment, which they weren't legally entitled to, in the sense that they came to quite a lot of subjective decisions, which in essence the inspector just adopted rather than the inspector doing them. And the legislation relating to planning appeals and the role of the inspector was the inspector should have done it. The judge allowed the appeal. There's been a little bit of speculation already within the planning law press that this might lead to a number of appeals coming up where the inspection has not been carried out by the inspector, but that is not the point. It wasn't the fact that the inspection was not carried out by the inspector. It was the fact that, having carried out the inspection, the planning officer then came to a range of detailed conclusions of quite a detailed and very significant impact upon the ultimate decision, which was above and beyond the role that she could and indeed should have performed, although the court was very clear they were not critical of her for what she'd done. It was just the way the process worked, which was flawed. So it is a planning case. It's unlikely to change the law in relation to delegation, but it's one that's just worth keeping an eye on, because, again, I understand that is going on appeal, although that's yet to be confirmed. That's Smith and the Department for Levelling Up down and a roundabout. Next slide, please. Ali. Ali is a case that is potentially, I hope you don't have to use it, but potentially, if you do, very, very useful. This is about a council employee who accessed and disclosed to the claimant's husband information about the claimant and her 2 young children. The court applied the Morrison Supermarkets case in relation to the position of vicarious liability, corporate liability for bodies, including local authorities, for the actions of their employees in terms of unlawful and willful data disclosures, which is always a large and potentially very expensive concern, obviously reputational risk, etc., for large bodies like local authorities who are using a huge amount of personal data. And the court decided that B was on a frolic of her own. I do love the word frolic, but it's very appropriate in this case. And the safeguarding elements of B's role underscored the extent to which she was not engaged in furthering the local authority's business, but instead was engaged in furthering her own ends. It doesn't take the Morrison case any further, but it applies it fairly and squarely to the local authority world. Should you get a employee of your council who goes off on a frolic and does something they shouldn't do in relation to data, I'd recommend you grab Ali as your potential 3rd or 4th port of call and have a good look at it, because it's very, very helpful. Next slide, please. Now, a couple of community care cases, but a couple of them I've included because they don't just touch upon community care issues per se. They have a broader corporate potential impact, so are worth, if you're operating in a different area, having an awareness of the fact that the court has dabbled in something that might impact across more functions than just community care. The first one is a predominantly community care issue, and the focus of the judgment, if we return to the High Court first of all, because this is the 2022 Court of Appeal decision, but in the High Court, they held the council erred in law in concluding that it had no power under the Care Act 2014 to contribute to the funding of outings or holidays for 2 individuals and their carers, as they met the eligibility criteria and regulations, and the duty under the 2014 Act was engaged on the proper interpretation of the Act. The court said, unable to find any statutory basis for the restrictive interpretation of needs that was adopted by the council. The natural and ordinary meaning of the word care is the provision of personal services. Care and support are not synonymous. support was added by Parliament to denote something in addition to care. The Court of Appeal said, I accept the needs of the respondents to take part in recreational activities, which include holidays, and this arises from their physical and mental impairment. Financial support previously provided by the appellant is not simply a means of paying for the respondents to go on holiday, it's a means of meeting their needs to rise for and are related to the physical and mental disabilities from which they suffer. It's a need which can't be met without financial support from the appellant, who was the local authority. One of the purposes of the Act is to provide support to individuals taking account of all their circumstances. Account has to be taken of past traumatic events. They will only trust their mother as their carer. So ultimately the court said, yes, you must meet their needs, and their needs include, etc. As I say, fairly narrow community care case, but quite an important one. Ham raises some other interesting issues as well as being a community care case. Ham was a Sudanese national who arrived in May 2021, claiming to be 17 years old, and was assessed by Kent County Council as being 23 and Brent as 23. The issue turned on assessments, and it's come back in a number of contexts about where there is a non-statutory, in other words, a non-prescribed assessment decision to be made by a council. How do they go about doing it? What the court said in relation to the assessment carried out in relation to Ham was there was no burden of proof, so no assumption either way. Rather, the assessment required must be undertaken in its own terms. It must be made based on reasonable inquiry. The authority must take steps reasonably in the case to obtain information needed. What will be required would depend upon the circumstances. Fairness might require decision makers to make further inquiries, possibly through an interview or other ways. If an interview is undertaken, it must be fair. Issues should be made clear and dealt with head on during the process. In this case, a provisional view of dishonesty and the reasons for it should have been explained, and the individual should have been given an opportunity to respond before a final decision. And this is the fourth point, is perhaps where we've seen a step from community care into other areas. Fourth, there may be a range of things an authority can do to ensure a procedure is followed. A procedure that is followed is fair, but there are not requirements of fairness in every case. There's not a binary approach. Quote, I appreciate that in practice all local authorities place a high premium on certainty. If the requirements of fairness could be reduced to a simple checklist, it would in every case be clear what the law required. That would be true, but what underlies the council's submission in this case is that the full Merton compliant, that's the London Borough of Merton's checklist for this particular process, has become too long and too onerous to be applied in every case where an age assessment needs to be undertaken. Hence the contention that some other shorter checklist, a short form assessment, is sufficient as a matter of law and manageable practice. But such prescription would be a hostage to fortune, because the requirements of fairness are always sensitive to circumstances. So that was the point the court came to. And I think it's the point that has stood out, but it's a point that has come up now, as I say, outside the community care world. And I stress it's where there is an assessment process which is not in any way, shape or form prescribed, but reducing it to a simple form of consistent checklist can run the risk, obviously, of, as the court said, the requirement of fairness is sensitive to circumstances. Sometimes you may need to do things, other times you may need not to do so, and simply always following a checklist doesn't work. Put in even cruder and more direct terms, which I'm sure colleagues will understand, therefore why the reason this came up. If you take a complex process and try to reduce it to a simple checklist that can then be undertaken by unqualified, cheaper staff or even a computer system, demonstrating fairness as an outcome of that process is going to be harder to do. Very simple and very obvious, probably. AB, which is the bottom one on that page. This was the administrative court dismissing a claimant's judicial review challenging a decision to close a day and resi care centre during the first COVID national lockdown. The claimant, who had learning difficulties and a number of other conditions, had attended it 5 days a week for many years prior to its closure. Basically, in summary, the court held that on the facts consultation taking place at a formative stage, the Cabinet had considered the implications of closure. The Cabinet had put in place safeguards for checking needs would be met. The provider service public consultation summary sent to service users and made it clear the defendant had significant financial challenges and that its money, that's the council, and that its money and resources needed to be used in the most effective way to meet the needs of the most vulnerable. That's the second gunning principle. Gunning, of course, the one that set out the criteria for consultation, which is so frequently repeated and endorsed by the courts. This had been clear to service users, families and carers. One of the options being considered for the Cabinet was clearly possible closure of priors, and the financial rationale for that was set out in the summary. Further, and amongst other things, the court held there was no principle in law to the effect that before a local authority changed the way it delivered services provided to many people, it had to assess the needs of each service user and match those to alternative service providers. So it's a useful case to consider if you are having to consider potential service closure and you're looking at consultation. It doesn't, again, say significant new things, but I think it continues to reaffirm getting it right does mean getting it right, but also what getting it right looks like, which is very helpful sometimes when you're trying to propose or redraft or assist a service department with how they go about effective consultation and how you go about an effective decision-making process. So a good one to keep in hand. Charging policies in the next slide, please. This one, which involved the City of London, related to a claimant who was disabled, suffering from arthritis, chronic obstructive pulmonary disease and depression. It related to the City of London introducing a new charging policy for the ladies' pond. The challenge was that the policy was discriminatory on the grounds of disability under the Equality Act. The charge was levied under Section 19 Local Government Miscellaneous Provisions Act 1976, which has a power to provide recreational facilities, including on payment of such charges as the authority think fit. I think this case is useful if you're looking at charging policies, because the Norfolk case, which came out in 2020, in which a charging policy was found to be discriminatory under the HRA, caused many local authorities to go away and review their charging policies. I think the articulation of the principles in this case will provide some relief to LAs, and is to some extent the court's wheeling back from Norfolk, which I think many people thought was a bit on the excessive side. So the court, first of all, rejected the claimant's submission that the council had failed to make reasonable adjustment to its charging policy. The claimant's case had essentially been that the discount for those of a limited income had discriminated against disabled people, a significant proportion of which are of limited income. But it couldn't be argued that one group of people with limited means should be favoured over another by reason of their limited means. When comparing the disabled impecunious, the court said to the non-disabled impecunious service users have both received a discount, and it's going to be very hard for a disabled claimant to show disadvantage. The judge said, I do not accept that the necessary connection exists. The flat charge for all puts people who share a particular service user's protected characteristics at a particular or substantial disadvantage when compared with people who do not have that characteristic. The simple root problem is a lack of disposable personal income, and the disabled and non-disabled, who all receive a concession if on benefits, are equally affected. So the authority's position was upheld. If you're in the process or when budgets come around of looking at charging policies, this is a substantial wheel back from Norfolk, and I think very useful. And the court spent some time setting out principles, which is very helpful. Next slide, please. The public sector equality duty, two cases I want to mention in relation to this. First of all, the Lambeth London Borough Council. This was a Court of Appeal. They dismissed the appellant's appeal against the judge's order dismissing her claims for statutory review and judicial review of experimental, underline the word experimental please, traffic orders. The appellant had been physically disabled and would rely on her car for every journey from home. She'd argued the traffic order made by the council had restricted the movement of vehicular traffic in her area. The council had overlooked the consequences of orders on disabled people, failed to comply with the PSD in section 149. Court held the judge had been correct to hold that when the council had made the experimental traffic orders, it had lawfully discharged its PSED. It had due regard to the implications of the decision it had taken at that stage. The PSED had been clearly explained in an inequality impact assessment and clearly in the mind of the council's strategic director when he'd taken the decisions that had given rise to the traffic orders. The court, I have to say, was mindful of the fact that these were experimental, so these were not permanent, and was mindful of the fact that they needed to be made relatively quickly. What I think is interesting, and I'm not going to go into it in great detail, is that not everything that the council did was perfect by any stretch of the imagination, and there were some glitches in the process. But the court said what had been done was proportionate in the circumstances, and imperfect isn't always illegal. So good one to have a look at that. Good one to have a look at. Binder in part allowed a claim for JR brought by 4 disabled claimants that the Defendant Secretary of State hadn't consulted lawfully via its UK Disability Survey before the Secretary of State had published a national strategy document, and that consequently the strategy was unlawful. The strategy hadn't made any detailed changes to law or policy, but had provided a policy framework within which more specific future policies would be developed. Consultation had therefore been legally required in order to avoid conspicuous unfairness or irrationality insofar as that went. But what had been produced hadn't lacked substance and had made immediate commitments. And on that basis, there were that part of the claim was allowed, the previous part was not. So again, it's a useful one if you're considering whether or not and the extent to which you need to consult on a strategy or policy. The Secretary of State got it 50% right and 50% wrong, but it's a good one to have a look at because it gives you some parameters where you do and where you don't and the extent to which you do. So a good and useful one I would suggest to have a look at. Next slide, please. Okay, so I'm now going to move on to talking about elections, because I always talk about elections, and I'm going to talk just a little bit more about elections. If you're lucky enough to have elections this May, the Elections Act 2022 will be enforced for you. So you could have council elections, you might have something else, but certainly if you've got council elections, the Elections Act will be enforced in 2 regards, but only 2 regards: voter ID and accessibility. I'm not going to talk about accessibility, and indeed I'm not going to go through all of the slides, but I do want to mention a couple of points, and I want to draw your attention to what's currently kicking around in terms of the major legal issues and the answers to those questions. I fear if you do have elections, whether you are involved as the returning officer, deputy returning officer, working at the county polling station, you could well be drawn into giving your RO some legal advice or dealing with people who are telling the RO that they do or don't have to do certain things, because unfortunately voter ID has become a very politicized issue, and really an election should always be about the candidates, the policies, not about the mechanics of the running of the poll. But May's elections will have a big focus on how voter ID does or does not work. It's also not helped by the fact that the legislation is late. The regulations have only just come out, and we're still waiting to have our first significant play with the computer system, although there's a number of beta pilots kicking around, and we're less than 6 months away from polls. So in terms of preparedness and readiness, we're not. So it is potentially a bit of a minefield we're stepping into. So even if you're not directly involved in delivering elections in any role whatsoever, but you've got elections in your authority, this May, you or your colleagues may get asked to dabble quite heavily in what's in the Elections Act 2022 that will be enforced for the May 2023 polls. So there's a couple of things I want to talk about on the next slide. So if I could have the next slide, please. Voter ID will have to be produced by voters if they want to vote in polling stations in May. They can either produce one of the things listed, or they can produce what's called a VAC, a voter authentication card, or a VAC. Can I have the next slide, please? The onus, and I will come on to this at the end when I talk about the key legal issues, is on the presiding officer to make the judgment about compatibility. So they've got to make a decision as to whether or not that person is that person based on the photographic ID they're looking at, and they must refuse to issue the ballot paper if it raises reasonable doubt. They get into the world, for those of you who understand and have followed elections, they get into the world of prescribed questions, which is a well-trodden path in the polling station and something that we argued for as returning officers very hard and got, because once you get into a situation where you doubt whether the voter can in fact vote, using the prescribed question process really takes us back into what I would describe as the normal processes rather than having to invent another one. However, there's a judgment call when the presiding officer looks obviously at the photograph on the passport or whatever it is, and then looks at the person standing in front of them and has to figure out whether that might by any chance be the same person. I will come back to that. Next slide, please. The voter authentication certificate is where people don't have photo ID. They will apply online in the same ways you apply online to register to vote. You apply online to do your car tax with DVLA, etc., etc. Regulations will set a deadline for the application, which is currently, as far as I'm aware, and it is in the regulations, polling day minus 6 days, 5 p.m. After that, you can't apply, but applications still in the system can still be processed because the application has been made within the deadline. I will talk about this. It's one of the 4 areas of potential risk for returning officers. There is emergency proxies available if the VAC doesn't arrive or ordinary photo ID is lost after the deadline. Next slide, please. Postal voting won't be in May. Next slide. These are the other matters that also won't be in May. Next slide, please. Delivery. Fairly straightforward, but we have, as it says, the third point down, late availability of the finalised regulations has meant that the Electoral Commission's guidance is not with us yet. We're hoping to see it in January this month. And there's still big questions around how the IT will work. It could well be that a lot more people are needed. And I'll come on to explain why that is the case in a minute. And if you work in legal democratic, it's the kind of area where certainly I, as returning officer, will go and just say, fine, I need an extra 20 people for the next 5 days. You're all coming downstairs to help run the election. It's just the way you have to do it. Next slide, please. So there is some money coming over to returning officers to support them deliver this, and I've started to spend my money, some of it on communications and some of it on kit. There are some saving graces with this, which is sections 23 and 48 of the Representation of the People Act 1983, which are referred to in the slide, which is the power to correct clerical errors at local and general elections, as well as sorry, it's not. It's the provision in the RPA 23 and 48 are the provisions that explain that if somebody wants to challenge the returning officer's conduct of a poll, they have to prove that the returning officer has substantially not conducted the election in accordance with the rules, and that substantial non-compliance has affected the result. You get a degree of latitude. Elections are never perfect. They're always imperfect. It's just, it has to be substantial non-compliance plus affecting the result. Section 46 of the Electoral Administration Act 2006 is the power to correct clerical errors. Those 3 things are going to be really useful for the next few polls. The legal areas to watch out for. The first, and these are the things that are currently popping up, and they've popped up with me at VEALS, they've popped up with me through Solace on behalf of returning officers, and I was dealing with one for the weekend that came from 6 very senior chief executive returning officers who were proposing, believe it or not, sorry, I'm talking to lawyers, you will believe it, but you shouldn't. Well, they didn't have to comply with the legislation because. So, first of all, the intention of the politicians when they first announced this legislation was coming was that they described it as saying, you know how you go to the post office and pick up a parcel? Well, it's going to be a bit like that if you want to vote. It's not going to be that onerous. You just sew a bit of photograph and it's all good and it's all fine. I think that the regulations that deal with voter ID, and there's 2 sets, there's one for councils, principal councils, as well as parish councils, and then there's one for general elections, neighbourhood planning referendums, PCCs, mayorals, etc. I can't remember how many pages they are now for the life of me, but I'm going to say it's over 100. So the level of granularity and detail and the obligations and the process that has to be followed bears no resemblance to that pop to the post office to get a parcel and waving a driver's license under the window. Although in essence, that's what it should and could be for many people. But this is a legislative process. You going to get a parcel is not a legislative process. And the fact that that's what you were told it was going to be 2 years ago when a politician said, don't worry, it's not like that. And you will understand, I'm sure, that the law on elections is prescriptive and requires people to do things in certain timeframes, has to be followed. And the law on this is exactly the same. It's highly prescriptive and directive. And there are huge amount of detail in the regulations so that the government gets this done the way they want it. And it doesn't bear a lot of relationship to that. So anybody who says, no, we only have to do what we were told by the minister, no, you have to do what the law requires you to do because it's your job as a returning officer to run the election in accordance with the law of the land. I mentioned the voter certificates, the one where people don't have passports and driver's licenses, and the fact there's a deadline on day 6 to apply. If you've got applications stuck in the system, the returning officer has a discretion. The returning officer, electoral registration officer, has a discretion as to whether or not they work on them before polling day and try to get as many as they can out. I have a choice as a returning officer in Southampton, and I've made a choice that I don't want anybody to disenfranchise that I can avoid being disenfranchised. And if somebody has applied but made an error in their application, which means it's stuck in the system because they haven't attached a photo or whatever, I have the discretion to go in and fix that, or rather, I have the discretion to have staff to go in and fix it. And I'm going to do everything I can to avoid people being disenfranchised, because I'm sure that's not the policy intent. So I am going to clear anything I can in the system. That has a resource implication because it's 6 days prior to polling day, and it's the busiest 6 days when we're fighting as well with late registration applications, which are also stuck in the system because the deadline's passed, but we're still dealing with them. And most of those people will want an absent vote as well, or often seem to, and their application will be stuck in the system. So there's a lot of paperwork. So we're looking at bringing extra people in and spending some money on that so we get nothing stuck. There's a bit of discretion there. It is a discretion. But I don't want to be accountable for explaining to my members when you've got council elections, very small margins of majorities, that, yeah, there were a couple of hundred people who didn't get their voter authentication certificate who couldn't vote. But hey, I had a discretion. Doesn't feel to me a very right thing to do. Doesn't feel a very safe thing to do, but it's not the right thing to do. And I don't want to disenfranchise anybody. One of the arguments that's been put up, which is wholly spacious, but is worth mentioning, is that the Representation of the People Act, sections 1 and 2, start initially in sections 1 and 2 with very global statements that if you meet the following criteria, you're in the franchise and therefore you're eligible to vote for general elections and for council elections. And a number of people have said, well, that sections 1 and 2 of the RPA have not been amended, so therefore voter ID is subject to that. So therefore refusing somebody a ballot paper because their passport photo looks questionable is a breach of section 1 and 2 of the RPA, so don't do it. The law on elections isn't always easy to follow, but basically the fact that you're in the franchise and you're eligible to vote doesn't mean you can vote. It doesn't say in sections 1 and 2 of the RPA 1983, for example, that if you turn up at a polling station at 11 o'clock at night, the people will have gone home and you can't vote. But it is the case. It's actually 2 parts. Are you in the franchise? And if you're in the franchise, are you able to vote? You might be in the franchise, but you're not able to vote because you don't get to the polling station in time, or you don't produce valid voter ID, or you refuse to produce voter ID, or a range of other reasons. So sections 1 and 2 have nothing to do with it because you might be franchised but still not able to vote. And we already know that, polling stations do close down and they don't just reopen because somebody turns up at 11:30 and says, I want to vote. Nonsense. So, that argument doesn't hold any water, but it has been mooted about. And the last point I wanted to make, and then I will shut up, is a very granular one, but it is the point about what actually is the decision that has to be made by the presiding officer sitting in the polling station when somebody turns up with voter ID. And if you'll forgive me, I'm flicking through pieces of paper because I've got this somewhere here and I want to find it because it's both material and germane to the issue. There we go. Sorry about that. Pieces of paper. Right. The regulations relating to principal councils, if you have elections in 2022, are the voter identification (principal area, parish and GLA elections amendment rules 2022, and it's 1397 of 2022. And if you go into part 2 and regulation 4, you find, as with all these regulations, they amend other stuff. So put a wet towel around your head, or get hold of something that enables you to go back to the principal things. Now, the rules to run principal elections are contained in the Local Authorities Principal Area England and Wales Rules 2006. And the relevant bits that I'm going to refer to, which are all about what the presiding officer has to decide and the test in the polling station, are all amendments to the rules in those 2006 regs. So if you've got a system that updates those effectively, great. If you haven't, you're going to have to read this alongside it. But either way, it's regulation 4.7 that deals with principal councils and polling stations. And the voter produces a specified document to a clerk initially, and the clerk decides the document raises a reasonable doubt whether the voter is the elector. or the voter produces a document the clerk reasonably suspects to be a forgery, in which case it goes to the presiding officer, who must refuse to deliver a ballot paper where the voter produces a specified document, and the presiding officer decides the document raises a reasonable doubt as to whether the voter is the elector, or produces a document that the officer reasonably considers to be a forged document. And then that has to be recorded. So one of the questions that has been asked is, what does that mean? Well, the Electoral Commission are currently grappling with their guidance for polling station staff, and their polling station handbook are going to provide some clarity about what reasonable doubt, etc., means. We are working with them and encouraging them to take a, how can I put it politely, franchising view, which is it would be better to franchise people than disenfranchise. So disenfranchise when you're certain. Bear in mind that there's no problem, apparently, with producing an out-of-date passport. It doesn't have to be a valid document in many cases that people produce. It just has to be a document where you look at the photograph and they broadly look like the person concerned. So we're not talking about a massively high test, but we think in many cases the issue isn't going to be that they don't produce a document which is a good likeness. They simply don't produce a document because they didn't know they had to, or they refused to do so. That would seem to be the experience from the pilots, in which case that's down to communications. However, those are the 4 areas of things that have come up repeatedly, and I hope those are helpful. And that's me done. Next slide, please.